Good morning, everyone. Good morning, Zinia. Good morning, Mehul. Uh, Today, we are going to discuss the case of Prathvi Chauhan versus Union of India. Now, the name of the case sounds like the case hails from the medieval ages, from the 11th century AD. But Prithvi Chauhan versus Union of India is a case from the year 2020. So, this is a writ petition criminal number 1015 of 2018 before the Supreme Court of India with Justice Arun Mishra, Justice Vineet Saran, and Justice S. Ravindra Bhatt on the bench. And the date of the decision is 10th February 2020. Okay. Now, before I begin the facts with the facts of the case, I should ask you that if you have come across or if you have ever heard or learned about the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Do you know or do you have any idea or even a little idea about the SC ST Prevention of Atrocities Act 1989? Any idea about the act? Okay, Suruchi. So what it is about? Mehul also says yes. All of you would say yes so far as my understanding goes. But I'm asking what it is about. Okay, so it is about a criminal. It is a penal law. It is a penal law because keeping in view the social status and the stigma that is attached to our society was that since ancient times, the scheduled caste and scheduled tribes were looked down upon with this approbation in the society. The origin of untouchability also started as a practice against them only. And if you go back to the Vedic times and if you find that what kind of society that we have inherited from our ancient society, you would come across the one system that had existed in the Vedic society, in the Rig Vedic society. Okay, what was that? That one system is division of society based on color, and there were four castes: Brahmin, Kshatriya, Vaishya, and Shudra amongst the ancient Hindu society. In the ancient Hindu society, okay. Now this division of society is what we have inherited from our ancient times, and we have continued to live with it, and we have worsened the situation more. Rather than improving upon it and rather than keeping such practices aside, we have in fact inherited these kinds of practices. Untouchability as a form of practice had started against the SCs and STs primarily. So SCs and STs, because that they have been looked down upon with this approbation, they have faced atrocities in the society. And some words have been specifically devised to abuse the people belonging to scheduled caste or scheduled tribes. Okay. So as Suruchi says that it is there to reduce the harm against the member of the SC and ST. Yes, exactly. Against the physical harms, against the mental harms, against the social harms. Okay. To prohibit hate crimes against SC and ST. That is more specific answer, Bajjas Badatum. That is a more specific answer. Okay. So, there have been acts and practices in the society which were harmful to the SCs and STs. So this law was made Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. So this Prevention of Atrocities, the name of the law itself suggests that what is the purpose of that law. Okay, what the law does. The law prevents the atrocities against the SCs and STs. SCs and STs in Indian society have been subject to utter torture and insult. Okay, they have been looked down upon with disapprobation in Indian society. Okay, they have been facing untouchability. They are not allowed to enter temples and other public places. This is what these kinds of things are: atrocities. They are not just mere prohibitions. They are in fact atrocities, because we are not giving them a dignified life, which is their right. Okay. And who has created this caste-based difference? Who has created this caste-based difference? No one else except only the society. And we have created these differences without any genuine reasons. Okay. Now facts of the case. And what happened? That this Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 is a law which prescribes that once an FIR or a complaint is lodged by a member of the SC or ST against any person, SC or ST against any person, that any such person or accused has committed, or in which you can say the person was accused of committing any sort of atrocity against that particular complainant, then in that case, upon a mere information, the police has authorized to arrest the person right away without conducting any preliminary inquiry. What is the normal course of action when a crime occurs? Normal course of action is that if, for God forbid, you are the victim of any crime, you will go to the police station, you will inform the police, and if the police after conducting a preliminary inquiry will convert your complaint into an FIR. Okay, if upon the preliminary inquiry, if it is found that the allegations made by you are correct to some extent, or there is some thing which needs to be investigated, then complaint can be converted into FIR by the police. Okay, but this happens only after a preliminary inquiry is conducted by the police. But under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, if a member of the SC or ST files a complaint before the police officer or in any police station having the jurisdiction against any person of the other caste, accusing him of committing any atrocity against him, then in that case, without conducting any preliminary inquiry, the police was authorized to arrest the accused right away. Now, this stringent action, which was prescribed and legalized by the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, started being misused in the Indian society, just the way sections and provisions like 498A of the IPC, which is cruelty, domestic violence. Now, these are the general provisions. You would have come across cases in which women have misused the laws which have been made for their benefit. Okay, they have misused the Criminal Law Amendment Act 2013. There are cases where false reports have been lodged by the bride against her husband and the relatives of her husband, just in order to extract undue benefits from them. Okay, or to insult them in the society without any reason. So what happened in section 498A? The police is authorized to arrest the accused right away. There have been katina of cases in which the police has arrested the husband and his family, and on later stage subsequently it was found that the complaint was false. No evidence was found of any cruelty, no evidence of any cruelty or any domestic violence was ever found by the police. Okay. Then in that case, the Supreme Court said that in cases of Section 498A IPC, it is better that a preliminary inquiry should be conducted, and if something wrong or fishy is found by the police, only then the police should be competent enough to convert the complaint into the FIR. Same was the case with the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. That when the members of the SC and STs, they started misusing the law. Like for example, if you are my subordinate and I am your boss in any company or office, and I am reprimanding you for not doing something, I am absconding you for not doing something, or for your negligence or carelessness, or your callous attitude in this office, then I am simply reprimanding you being your boss. You are my subordinate. I have the right to scold you. Okay, I am not scolding you because you belong to a particular caste. I am not the boss because I belong to a particular caste. We share a professional relationship, right? We share a professional relationship. But in cases of SCs and STs, what has been usually observed, that members of the SCs and STs have even taken a simple reprimand, which was not caste based, but rather it was professional, it was personal. But members of the SCs and STs, they used to visit the police station and lodge a complaint against persons who who reprimanded them, okay, who scolded them, not for the reason that they belong to the SC or ST caste, but rather there was some callous attitude or there was some professional misconduct on their part. Okay, and what the police used to do? The police had to arrest the accused right away without conducting any preliminary inquiry. So, keeping in view this problem, the Supreme Court in 2018 said that under SC ST and Prevention of Atrocities Act 1989, the police is supposed to conduct the preliminary inquiry and should not arrest the accused right away. A preliminary inquiry has to be conducted in order to find out if the truth exists or does not, or it does not exist at all. Because there are false cases which we are discovering in various issues and various cases. We are discovering that most of the cases now, the members of the SCs and STs, they are misusing the law. They are registering false complaints against the people of other caste just in order to torture them. They are taking undue benefits out of this law that nobody can say anything to them. That is not the case. Like if I am subjecting a person to utter cruelty, violence and insult just because he belongs to the scheduled caste or scheduled tribe, that is an offense. But if I am reprimanding somebody who belongs to the SC and ST, not because he belongs to the SC and ST, but because of his any professional misconduct or any other reason, I should not be convicted of any offense under the SC and ST Prevention of Atrocities Act 1989. Okay, I am simply reprimanding him because there has been a callous attitude on his part or any professional misconduct or any personal misconduct. Okay, but if I continue to mix the two things and if I continue to reprimand him and start abusing him of being an SC or ST, then definitely this would turn into a crime and I will be liable under the SC and ST Prevention of Atrocities Act 1989. But in most of the cases, the members of these SCs and STs, they've started lodging false complaints against the people of other caste just in order to extract undue benefits out of the law. Keeping this problem in view, the Supreme Court said that first a preliminary inquiry should be conducted by the police to find out if the truth exists in the complaint or not, and if something fishy is found, only the police should move ahead while converting the complaint into the FIR, and proper action needs to be taken thereafter. Okay, have you understood so far? When the Supreme Court gave this judgment in Subhash Kashinath Mahajan versus the state of Maharashtra and another, okay, that was the case. See, this was the case in which Subhash Kashinath Mahajan versus the state of Maharashtra and another. It's written here in bold italics. Okay. In this case, the Supreme Court said what I have just told you, that preliminary inquiry should be conducted by the police before the arrest is made. Okay, only, and the police should move ahead in the case only something when something fishy or some truth is found. Okay, right? Have you understood? Subhash Kashinath Mahajan versus the state of Maharashtra and another. But in this case, when the Supreme Court ordered this and said this, I'm sorry. Right. But the members, this outraged, this judgment of the Supreme Court outraged the members of the scheduled castes and scheduled tribes who were out on roads to protest against this order of the Supreme Court. They started vandalizing the public property, and there was huge disturbance to public order and peace and tranquility of the society. Okay. Have you understood? People of the SCs, the members of the SCs and STs, they started coming out on roads protesting against this order of the Supreme Court. They started blaming the government, without even knowing that the order has come from the Supreme Court and it's not the government which has declared this. Okay, it's not. And they started protesting against the order of the Supreme Court, and they started blaming the government, that the government is anti-Dalit, and we live in an anti-Dalit society where we still have to face atrocities, and there's going to be no redressal for against our atrocities. And they started vandalizing the public property. Okay, they resorted to violence which disturbed public order, peace and tranquility. Okay. Then thereafter, subsequently, in order to please the Dalit vote bank and to contain the situation, the government of India brought Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018. Okay, 2018, which incorporated a new section under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Okay, and that was section 18A. Subhash Kashinath judgment is from the year 2018. Okay, Subhash Kashinath judgment is from the year 2018. Okay. In 2018, when the members of the SCs and STs, they started protesting against the order of the Supreme Court in order to please the Dalit vote bank, in order to please the Dalits for securing the Dalit vote bank, the government of India, while nullifying the judgment of the Supreme Court in Subhash Kashinath Mahajan versus the state of Maharashtra and another, brought and introduced Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018 and incorporated a new section called Section 18 capital A, Section 18A, that nullifies the decision of Subhash Kashinath Mahajan versus the state of Maharashtra and another. And what does this Section 18A says? I'm reading Section 18A. Please listen to me very carefully. No inquiry or approval is required. For the purposes of this Act, A. Preliminary inquiry shall not be required for registration of a first information report against any person. Okay. For the purposes of this Act, A. Preliminary inquiry shall not be required for registration of a FIR of a first information report against any person. Like if, for example, the thing that I have already told you and explained to you, that if any member of the scheduled caste or scheduled tribe lodges a complaint The police need not conduct a preliminary inquiry and register the FIR right away against the accused, or the investigating officer shall not require prior approval for the arrest, if necessary, of any person against whom an accusation of having committed an offence under this act has been made, and no procedure other than that provided under this act or the code shall apply. Okay? The investigating officer shall not require approval for the arrest, if necessary, of any person against whom an accusation of having committed an offence under this act has been made, and no procedure other than that provided under this act or the code shall apply. Right? Have you understood this? That the investigating officer even does not require a prior arrest warrant for arresting the accused person. Can you understand the depth and intensity of the strictness that has been accorded to this law? The provisions of section 438 of the code shall not apply to a case under this act, notwithstanding any judgment or order or direction of any court. So basically, this new section 18A was incorporated deliberately in order to nullify the judgment of the Supreme Court in Subhash Kashinath judgment versus the Subhash Kashinath judgment, in which the Supreme Court had ordered to conduct the preliminary inquiry before registering the FIR. But this section nullifies the judgment of the Supreme Court and says that preliminary inquiry shall not be required for registration of an FIR against any person, and even the investigating officer shall not require any arrest warrant or any prior approval for the arrest, if necessary, of any person against whom an accusation of having committed an offence under this act has been made. Okay, have you understood? Have you understood this? The court introduced several safeguards in the Kashinath Mahajan case. Now let us first understand that what the Supreme Court said in the Subhash Kashinath Mahajan case. In Kashinath Mahajan case, the court introduced certain safeguards. Okay, but the Parliament overturned these safeguards by the amendment in this act. The safeguards are given in this case were conduct of preliminary inquiry before registration of FIR. The Supreme Court said that preliminary inquiry should be conducted before registering the FIR. Investigating officers should receive approval before arrest. Before arresting the person, investigating officers should receive approval before arrest. Third, anticipatory bail to the accused, notwithstanding any judgment or order or direction of any court. If the accused shall be given an option to seek anticipatory bail, notwithstanding any judgment, order or direction of any court. What is anticipatory bail? That if the person has been threatened that a false case can be registered against him, and he is suspicious of having been for being arrested in future or in some time to come, then he can seek anticipatory bail on genuine grounds. Okay. So the accused shall be competent enough or eligible to seek anticipatory bail, notwithstanding any judgment or order or direction of any court. So have you understood this? Have you understood this or not? Okay, so what did section 18A has laid down? Okay, that means provision relating to anticipatory bail even shall not apply to any case under this act. That means conduct of preliminary inquiry before registration of FIR has been kept aside by the new amendment. Investigating officers do not now require prior approval before arrest. anticipatory bail to the accused has been kept aside, and no provision or no provisions regarding anticipatory bail relating to the anticipatory bail shall apply to any case under this act. Okay, these were the safeguards, and this is how they have been diluted. Okay, when this amendment act was brought, Prathvi Chauhan immediately challenged the constitutional validity through a writ petition constitutional number 1015 of 2018 of section 18A of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018, that this new section is very strict, more than what is required, and this happens to violate the basic rights of fundamental rights of the people. Okay, this amendment has diluted the effect of Kashinath Mahajan. The Kashinath Mahajan judgment intended to prevent the people from abusing the act. After the passing of Kashinath Mahajan, the parliament took a step to undo the judgment, as it caused so much violence and protest by the Dalits and Adivasis group, and placed the amendment bill in the parliament. A review petition challenging the Kashinath Mahajan judgment was filed before the Supreme Court of India. The legislature even has not waited for the court to hear the review petition filed, which challenges the judgment. Okay, that means legislature or the government was so desperate to nullify the judgment of the Supreme Court in Kashinath Mahajan case, that already a review petition against the order of the Supreme Court was filed before it. But the legislature did not even wait for that review petition to be finally decided by the Supreme Court, but rather went on to bring the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018 to incorporate new section called Section 18A to nullify all the security safeguards that were categorically highlighted by the Supreme Court in Kashinath Mahajan case. And they have been categorically diluted and nullified by the new Section 18A. These are all political stunts, however, but we have to understand and learn them from the prism of purely academic purposes. Okay, the Supreme Court issued a notice on 7 September 2018 to the central government to respond to the petition. Okay. In response to the notice, the central government filed an affidavit and stated that the legislature is competent to make changes through the process. Many acquittal cases under the SCs and STs Prevention of Atrocities Act do not indicate the cases to be fake. Okay. Several petitions were filed challenging the 2018 judgment amendment. On 13 September 2019, the review petition was referred by the division bench comprising Arun Mishra and UU Lalit to 3-judge bench. After hearing before the 3-judge bench, the court upheld the constitutional validity of the 2018 amendment. Okay, now have you understood the facts and the trajectory of the law so far? Have you understood or not? So Mehul Taran has understood, but Jaspat wants me to repeat the last point. What was the last point? Ananya says not, and then she says yes. Acha, okay, you want me to repeat the last point. Okay. The last point is, that when the Subhash Kashinath Mahajan versus the state of Maharashtra was finally decided by the Supreme Court in 2018, mentioning some of the security safeguards to be taken into account or reckoned with while disposing of a case under Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, that the police needs to conduct a preliminary inquiry, the investigating officer shall require prior approval for arrest, and the accused shall also be eligible to seek anticipatory bail. All these security safeguards outraged the sentiments of the members of the SCs and STs, who started protesting against the order of the Supreme Court and in fact started resorting to violence, vandalizing the public property, thereby disturbing public peace and tranquility. Okay, the government felt suspicious about losing the Dalit vote bank. In order to please the entire Dalit community and securing the Dalit vote bank, the Parliament, however, also the government of India filed a review petition against the order of the Supreme Court, against the order of the Supreme Court in Subhash Kashinath Mahajan versus the state of Maharashtra, and in fact was so anxious to settle the matter as fast as possible that it did not even wait for the Supreme Court to decide the reviewed petition, and went on to bring the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018, thereby incorporating Section 18A, which has categorically diluted all the security safeguards which were ordered by the Supreme Court in Kashinath Mahajan case. The Section 18A of the new Amendment Act of 2018 says that the Kashinath Mahajan case, and Section 18A says that preliminary inquiry is not required. Okay, investigating officer does not require prior approval of the arrest, and also the provisions relating to the seeking anticipatory bail shall not apply to any case under the Act of 1989. Okay, simple. So far as the review petition which was filed by the government of India against the order of the Supreme Court in Subhash Kashinath, against the judgment of the Supreme Court in Subhash Kashinath Mahajan case, in response to the notice which was issued to the central government to respond to the petition, the central government filed an affidavit and stated that the legislature is competent to make the changes through the process, and many acquittal cases under the SCs and STs Prevention of Atrocities Act do not indicate the cases to be fake, and therefore we do not want to create these we do not want these security safeguards to remain. We want them to go away, and that's what we are doing. We are trying to nullify the judgment of the Supreme Court by bringing this Amendment Act subsequently. Okay. Now several petitions. Now what did the Prathvi Chauhan do? Prathvi Chauhan simply filed a writ petition constitutional number 1015 of 2018, which challenged the constitutional validity of Section 18A of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018, accusing it of violating basic or fundamental rights of the accused. Okay, who was on the bench? Justice Arun Mishra and Justice UU Lalit. And finally, the review petition was clubbed with the writ petition constitutional number, and this was referred to a 3-judge bench. Okay, the court upheld the constitutional validity of the 2018 amendment. Now, have you understood? Now, if you have understood, we can move ahead with the issues. Have you understood or not? Okay. Now what were the issues to be mooted? whether Section 18A of the SC and ST Prevention of Atrocities Amendment Act 2018 is constitutionally valid. Because Prathvi Chauhan in this case is the petitioner, and we are discussing this case in which he has challenged the constitutional validity of Section 18A, accusing it of violating fundamental rights of the accused. So the basic main issue was that whether Section 18A of the SC and ST Prevention of Atrocities Amendment Act 2018 is constitutionally valid. Second, whether bar on granting anticipatory bail is valid and whether it infringes the personal liberty under Article 21 of the Constitution. Okay, whether bar on granting anticipatory bail is valid and whether it infringes the personal liberty under Article 21 of the Constitution. Okay, whether you if the new Amendment Act is putting a bar on granting anticipatory bail, is this provision valid? Does this not violate the personal liberty under Article 21 of the Constitution of India? Personal liberty of the accused. Every accused is eligible or has the right to seek anticipatory bail. Otherwise, this would violate Article 21 of the Constitution. His right to life and personal liberty would be violated under Article 21 of the Constitution. So, this new amendment, Section 18A, is putting a bar on granting anticipatory bail to the accused under SC and ST Prevention of Atrocities Act 1989. Okay, now the contentions made by the petitioners. Prathvi Chauhan, listen to me, don't confuse here. Prathvi Chauhan is challenging the constitutionality of Section 18A. He wants this amendment to go. He wants what the Supreme Court said in Subhash Kashinath Mahajan case to be restored back. Okay, so here the contention by the petitioner means the contention by the Prathvi Chauhan. The counsel for the petitioner contended that the safeguards introduced in Dr. Subhash Kashinath Mahajan versus the state of Maharashtra and another were necessary as the act was misused a lot. Okay, Prathvi Chauhan said that the act was misused earlier and the Supreme Court had rightly created the security safeguards under the Subhash Kashinath Mahajan versus the state of Maharashtra in another judgment. And they are necessary and they all should be restored. This amendment should go and all the security safeguards highlighted by the Supreme Court in this case should be restored so that it prevents any misuse of the law. It is further contended that the absolute bar on granting anticipatory bail will violate the fundamental rights granted under Article 21 of the Constitution relating to the personal liberty of a person. Okay. The petitioner also contended that if you are creating an absolute bar on granting anticipatory bail, this will violate fundamental rights of personal liberty under Article 21 of the Constitution of India. Because every accused has the right to seek a bail. Okay, right? The contentions made by the petitioner. Have you understood these contentions? Have you understood or not? Okay. Understood? Now contentions made by the respondents. On behalf of the central government, Attorney General K.K. Venugopal contends that the amendment was made due to a large number of acquittal cases and police failed to implement the act properly, and prosecution of the accused was also not effective. Obviously, it is Prathvi Chauhan versus the Union of India. A petition has been filed against the Union of India. It is the Union of India that has brought this amendment. So who is going to be the respondent? The Union of India. And who is going to represent, who is going to be the lawyer on behalf of the Union of India? Obviously, it's the Attorney General. Attorney General is Mr. K.K. Venugopal, who is also the senior advocate of the Supreme Court. Now, he contended while defending the 2018 amendment. See, I have not read the entire law of the 1989 Act, but most of the offences which have been created under the Act are non-bailable offences. Only the petty offences which have been created are the bailable ones. But most of them happens to be non-bailable. Okay. Okay. On behalf of the central government, Attorney General K.K. Venugopal contends that the amendment was made due to a large number of acquittal cases. Now he is highlighting the reason why this Amendment Act has been brought. Okay, he contended that in large number of cases where the accused was where the person was accused of committing offences under the 1989 Act, the people such accused, most of the accused have been acquitted. The police had failed to act properly, and the prosecution of the accused was also not effective. So in order to make it more strict and stringent and effective, these security safeguards should go away and Section 18A should stay back. The petitioner's counsel further argued that the amendment conforms with the aim of the Act, which states for the protection of the SC ST section of the society. Okay, the petitioner said that amendment also conforms or falls in consonance with the aim of the Act. What is the aim of the Act? To prevent the scheduled caste and scheduled tribes from any atrocity, and this amendment is exactly what the aim of the Act is. Okay, this amendment does exactly what the aim of the Act is. The aim of the Act is to prevent the atrocities against SCs and STs, and this is what the amendment. This is exactly what the amendment does. It is creating a strict or a stringent mechanism to prevent the atrocities against the SCs and STs. So it is also falling in consonance with the aim of the Act, with the purpose of the Act. Okay, so have you understood? He highlighted that prosecutions of the accused under this Act were not effective. There have been large number of acquittal cases and the police has failed to implement the Act properly. It is necessary to prompt the police in such cases, and the only way to prompt the police to take action right away is to do away with any sort of preliminary inquiry and any sort of prior approval before arresting the accused under the Act. Okay, that is simple. Have you understood the contention made by the respondent? Have you understood the contention made by the respondents? Understood? Okay. Okay. Judgment of the court. In this case, the three-judge bench of the Supreme Court of India has upheld the constitutional validity of Section 18A of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018 and had nullified the effect of the Kashinath Mahajan case. I must say, the Supreme Court as an institution itself, with due respect to the dignity and elegance of the institution, the Supreme Court has delivered the kinds of judgment it has delivered shows and mutely conveys that the Supreme Court is very unpredictable. In the case of homosexuality, in 2014 the Supreme Court said that it is an offense, it does not violate Article 14, and it shall continue to remain an offense. But exactly opposite of what was said by the Supreme Court in 2014 was done by the Supreme Court in 2018, said while highlighting or observing that it violates Article 14 and it's a violation of right to equality, and it cannot remain as an offense anymore. Okay, it cannot remain as an offense anymore. And Supreme Court in Kashinath Mahajan case said that the act has been misused several times and some security safeguard mechanism is necessary to prevent such misuse. And right after 2 years, the Supreme Court nullified the effect of its own judgment while upholding the constitutional validity of Section 18A of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Act 2018. Okay, the court held that the directions given in the Kashinath Mahajan case had placed an unnecessary burden upon the people of SCs and STs. While dealing with Section 18A of the Act, the court said that while looking into Section 18 concerning the preliminary inquiry before registration of FIR, the inquiry is permissible only in conditions laid down in Lalita Kumari versus Government of UP. Okay, only in Lalita Kumari versus Government of UP. Court further held that no anticipatory bail was given for offences under SC ST Amendment Act. Okay, we cannot allow anticipatory bail. Like the Supreme Court reversed all what was said by it in Kashinath Mahajan case in 2018. First, the Supreme Court said that Section 18A of the new amendment is absolutely valid. It's constitutionally and fully valid. Taran is saying that Supreme Court has been bestowed with this authority to depart from its own decisions under Article 141. That is exactly true. But this reversal was never practiced the way it has been practiced in the last 10 years. If you look at the record of the Supreme Court in the last 10 years, the Supreme Court is reversing its own judgment with greater speed rather than what it used to do earlier. If you look at the record of the Supreme Court, it's reversing its own judgment too quickly. That's what I am saying. I am not denying its liberty or authority to reverse from its own judgment. Obviously, the Supreme Court is all powerful to do that. It can say one thing today and exactly opposite of it can be said by it tomorrow. I'm not saying it. I'm not denying this. I'm saying the speed has increased. The frequency of reversal has increased. Okay. Okay, so first it upheld the constitutional validity of Section 18A. Then it said that no anticipatory bail provisions would apply to the cases or offences under the SC ST Amendment Act. In the concurring opinion, Justice Ravindra Bhatt observed that anticipatory bail could only be given in exceptional cases and not in every case. Anticipatory bail can be given in only exceptional cases. See, bail is a discretion. Mostly bail is a discretion of the court. And while granting bail, certain important social and economic factors relating to the accused are reckoned with or taken into account. So we basically cannot have strict guidelines for granting bail or granting anticipatory bail. It said that if the court finds some reasons to be exceptional, then in those cases anticipatory bail can be granted, otherwise not in every case. The court had earlier observed that the anticipatory bail could only be granted with no prima facie case under the SC ST Act. Justice Ravindra Bhatt, while delivering judgment, also states about equal treatment of all citizens and fostering the idea of fraternity, because the concept of fraternity is as important as the personal liberty of a person. Court further held that if an accused is a public servant, the arrest can only be made after appointing authority. If the accused is a non-public servant, the arrest can be made after the permission of the SSP. Okay. Soma Sundaram is asking, sir, so here the respondent is accepting the safeguards of Mahajan's case. I am asking this with respect to preliminary inquiry. No. Respondent, who is the respondent in this case? The Union of India. Who has brought this amendment? The Union of India. Okay. It is not accepting the safeguards. It is rejecting the safeguards of the Mahajan case. The respondent is contending that the safeguards in the Mahajan case has made the police quite lazy and reluctant in every case, because in every case the police has turned reluctant to do anything or take any action. The prosecution, this has rendered prosecutions under SC ST Act as ineffective. Okay. Okay. So that is why it is rejecting the security safeguards. Have you understood, Somasundaram? Now look at this. The court held that if an accused is a public servant, like any public servant is accused of committing any offense under the SC ST Act, now then in that case the arrest can only be made after appointing authority. Okay. If the accused is a non-public servant, the arrest can be made after the permission of the SSP. Okay. Now in this case, the constitutional validity of section 18A of the SC and ST Prevention of Atrocities Amendment Act 2018 was challenged. Now this is repeating, some of the things are being repeated here. So I'm skipping all of it because our discussion has finally come to an end. I mean, this speech part has come by mistake and this was not intended to be here. Okay, so the discussion on this case has come to an end. If you have any questions, please, you are most welcome to ask. No questions? Have you understood the entire trajectory of the issue? Like it started in 2018. The act hails from the year 1989. Okay. In the year 2018, it was felt that the act has been grossly misused. There was a petition by Mahajan. Okay. By Subhash Kashinath Mahajan against the state of Maharashtra and another, in which the Supreme Court held that the act was grossly misused and certain security safeguard mechanism has to be developed. Preliminary inquiry should be conducted by the police. The investigating officer should require prior approval before the arrest, and also the anticipatory bail can also be granted to the accused. Okay. Which outraged the members of the SC and ST, the entire community of SC and communities of SCs and STs. There, it was outraged. It was out on roads. In order to secure the Dalit vote bank, the government immediately brought the Amendment Act of 2018, which incorporated Section 18A, which categorically nullified all these mechanisms which were highlighted by or observed by the Supreme Court in Kashinath Mahajan case. Subsequently, this Amendment Act was challenged. Section 18A was challenged by Prathvi Chauhan as being constitutionally invalid, being violative of Article 21 of the Constitution of India. But the Supreme Court, while delivering the judgment, upheld the constitutional validity of Section 18A because it bought the arguments made by the respondents and said that in order for the prosecution of the accused under this act to be effective and in order to prompt the police to take the action right away, it is necessary to have some stringent laws, and the observation made by us in 2018 was about those security safeguards which had rendered the prosecution of the accused quite ineffective. So, and the police also quite reluctant from taking any action against under this act. Okay, that's it. Have you understood this? So I guess no more problems, no more questions, right? Okay, then. Okay, then I'm signing off, and you can download this Amendment Act from the any government website or legislative.gov.in, and you can have a perusal of section 18A. You can read it. Okay, there are only 16 pages. You can go through it, because going through such documents, develops your legal acumen, and it's better for you to understand these issues. So I would rather want you to keep yourself updated and posted every time about the happenings in the legal sector, in the legal field, or in the legal world. Okay, now since you do not have any questions, and the things are clear to you, so I am now signing off, and we shall meet tomorrow with another case. Okay, till then, all the very best. Bye bye.